Welcome to today's episode of In the Trenches, a new McDermott Health podcast on healthcare enforcement and litigation. I'm your host, Brian Stimson. I'm a partner at McDermott. And before joining the firm at the beginning of 2021, I was the acting general counsel and principal deputy general counsel, or second ranking lawyer at the U.S. Department of Health and Human Services. I am very excited to talk today with two of my new partners, also former government lawyers with decades, literally decades of experience at the Department of Justice, Ben Curtis and Carlos Ortiz. Gentlemen, thank you for sitting down with me today. Very excited that you're here. I want to talk a little bit about your experiences at the department, because I think you both have had fascinating careers and done some really cool stuff. And then maybe we can dive into the trends. I always think the war stories are more interesting anyway. So Carlos, maybe let's start with you. Can you set the stage and talk a little bit about your arc at DOJ?
Sure. So I actually started in the Army JAG Corps for 3 years and got an LLM in tax. My wife said the best part about that was we had a military wedding. So other than that, that was the part that she enjoyed. But I went from there to the Department of Justice Tax Division. And I spent 5 years in the Western Criminal Enforcement Section. So we're based in D.C., but all of my trials and all of my work, were actually in the western part of the United States. So I guess that's actually where I started. My very first trial was actually up in Anchorage, Alaska. So started out up there, where when you're picking a jury, one of the first questions you ask is, who has not thrown a Molotov cocktail at the IRS building? And anybody who is not, they're immediately on your jury. So I started out, learning combat by, up there. So that was the first bit. And that was a tremendous experience because, learning how to try paper cases. And I had a lot of trials in California and LA. And a lot in Portland, Oregon, which was also a tremendous experience. And then being a true Jersey guy, I came back to the Garden State and spent 10 years in the U.S. Attorney's Office here, and started out as a line attorney. But when I left, I was a deputy chief and acting chief in the criminal division, and I supervised about 110 AUSAs. And at one point, I was also the chief of the government fraud unit. So that was also a tremendous experience. And it was just, a great way to learn. And being a supervisor, especially at the highest levels, you learn a lot. You learn about what happens, how cases get decided. And it's something that I've taken with me into private practice, because you really do see, the factors that go into, especially the decisions that go into prosecuting individuals, discretion that prosecutors truly have, in making these calls. And also it's given me a lot of credibility when I go into now representing a company or individuals before DOJ or the SEC or AG's offices. So it's, I'm able to rely upon all of that now.
So approximately how many cases did you try when you were at DOJ? Was it something in the order of like 15 to 20?
Yeah, I tried about 21 jury trials, over the time I was at between tax division and the U.S. Attorney's Office. So, and, everyone was a little bit different. So, but it was a great, again, a great experience.
You also were honored for some of your work that you did. And it was outside the tax realm, but it was quite impactful and dealt with minors and their treatment. Can you talk a little bit about that?
Yeah, but then thanks, Brian. Yeah, that's actually one of the things I'm most proud of. When you're a prosecutor, you do have the ability to do justice, and I'm a firm believer, and I was fortunate to have that opportunity. And one of the things obviously we did was we prosecuted individuals who downloaded, and transferred child pornography. And at one point near the end of my career, I was watching, dealing with this, and had heard that folks actually were using their real credit cards to go online and direct folks to sexually abused, minors and like 5-year-olds on the internet. And listening to that, I said that, how is that so? And we were told, well, you can't really get those guys who are making money from it because they're overseas, they're offshore, and it's just too hard to do. And you said, well, someone has got to try. And at that point, I'd had a lot of experience in prosecuting financial crimes and said, well, we're going to do it. So we did undercover buys. We partnered with MasterCard and industry so we could do, lightning subpoenas and get information very fast. And through that case, we were able ultimately to follow money into banks in Latvia, and we lured folks from Belarus and to meetings in Paris where we arrested them with the help of French police. We extradited them back to the United States, and ultimately we were able to take down a organized crime cell operating out of Eastern Europe. Also, we got computers and we seized those and we handed out leads into 20 countries at Interpol, and which resulted in about 1,400 worldwide arrests. And it was a tremendous success that had never been done. And we seized them, $1.5 million. These guys were laundering about $800,000 every 2 weeks in commercial child pornography proceeds. So it was a landmark case, and incredibly, obviously, it was one of the most impactful things that I'd ever been involved in. And it just started with me sitting in my office and saying, we got to do something about it. So it was a great thing. And ultimately, we were honored in the White House by, at the time, President George W. Bush, W. And ultimately, we, in private practice, we formed the Financial Coalition Against Child Pornography, which was also great. And I was pro bono counsel for 10 years to that. And it involved 93% of the payment processing industry. And we cut child pornography, commercial child pornography, from a $2 billion industry to maybe a couple of million, which was a huge success. So protecting children was, an amazing thing.
That is amazing. So what was the cross-border element of that? You must have had to have worked with a lot of other countries and law enforcement agencies.
We did. We worked with the high-tech crime unit. We worked with law enforcement in France. And through that was one of the first experiences I had, with international law enforcement, and which has actually served me well, because today I represent a lot of international companies and travel a lot. And it's something that, we can talk about later on, but it's a big part of my practice. I have a lot of international companies. So in that case, we worked with, a lot of international, and handing out those leads was amazing because obviously, this was an internet case, and, the internet doesn't know any boundaries or any borders. So it was really important to get those leads out. And I remember one day we read about 800 arrests in Australia, of pedophiles. And that was rewarding. And that was because of the leads we developed and passed out. So it was great to be able to do that and eliminate something that the whole world cares about. We also helped form the European Financial Coalition Against Child Pornography, the Asian Coalition Against Child Pornography, and also the South American one. So at the time, it was just a great experience and a great thing to do.
And now you're in the private sector with all of us. Can you tell us a little bit about that? I know your focuses now are criminal tax, Fcpa, and healthcare fraud. What are the big issues that you're focused on in those areas?
Sure. So over the years, I've been in private practice now for 16 years. And, I've done, a significant amount of representing clients from all over the United States and the world, represented major pharmaceutical companies in Fcpa work, and it's the Fcpa can be a challenging statute to understand, even in the United States, but trying to understand it in a foreign country, where folks, you're dealing with understanding it, cultural issues that they're dealing with as well can be also difficult. So, I've had a couple of really great settlements, in that world. And it's important that, I've gotten to know the folks at Main Justice, what they care about. And so that's been, a great thing that I've been doing over the last 16 years. Also criminal tax, because of my background in tax, of those 21 cases, 16 of them involved criminal tax prosecutions. So I've represented major accounting firms. And, some of the issues that you see now are the IRS and Department of Justice are also chasing money, and overseas. Folks have been parking money like the Swiss bank cases. And now also virtual currency is a major issue, that the IRS is focusing on. There's something called the J5, not the Jackson 5, but the Joint International Task Force, where, law enforcement is now working together. And the J5 is, IRS type enforcement agencies in the United States, the UK, Canada, Australia, and I believe it's the Netherlands. And they're all sharing information. And I think that's something that, that we see, and they're issuing challenges to themselves, like virtual currency, and going after that in a joint effort to do this, collaboratively, which is something that we see now, and that's something that we're seeing, and it's a trend now with law enforcement working together. Same thing with Fcpa and anti-corruption efforts. So those are areas that we're seeing and that we're advising clients on as well. So while we're not in the government anymore, the cases we deal with and the challenge of assisting corporate clients and individuals in understanding these risks is really interesting. And I've enjoyed every step of the way. And I really enjoy working with companies in assessing these risks and addressing the challenges. And working with partners like Ben and you, Brian, coming aboard has really been enjoyable in a collaborative way. So it's I really enjoy what I do now.
I'd like to come back to that and also talk a bit more about digital currency, but would also like to hear from Ben about his trajectory at DOJ. Ben, I know you were there for 10 years and spent a good bit of time in the criminal division. Can you, for those members of our audience who may not understand the structure inside baseball of DOJ, explain where you sat within DOJ and what your arc was as you moved through the department?
Yeah, no, I'm happy to do that. I'm laughing. Arc presumes that there was rhyme or reason or intention behind anything that I ever did. I just kind of meandered, I think, with how my colleagues might want to describe it. Yeah, listen, I started out, I was very lucky. I was able to get a position with the Department of Justice in the early part of, I think it was 2005, with the Civil Rights Division. And not too long after joining the Civil Rights Division, I had an opportunity to go on detail, which is basically you're on loan to another U.S. Attorney's Office, which in this case was the U.S. Attorney's Office in D.C., which is great because, I mean, D.C., although they might disagree with this, depending upon where you are, it's basically a glorified DA's office because you have to, handle all of the local crimes. And so I had an opportunity to cut my teeth and learn how to try cases on numerous bench trials doing that. And then about a year and a half later, I migrated down to South Florida and worked as a AUSA for the U.S. Attorney's Office in Miami. I went down there. To me, it was a very lucky break because I just wanted to try cases. I felt like I was going to be a modern version of Crockett and Tubbs from Miami Vice. I had never been to Miami, but that was obviously what was running through my head at the time. And it was a great experience for me because there's a lot of activity there. I laugh. I've referred to South Florida as like the Ric Flair of crime because there's not a shortage of it. It's the all-time reigning champion, at least in my eyes. Went down there, had the opportunity to start out prosecuting a little bit of everything: guns, drugs, child porn, all sorts of different trafficking of you name it. And then after a little bit over a year, I was switched over to what was called the economic crime section in the office, where, again, in retrospect, it was very lucky. They put me on healthcare investigations. I did that for probably the next 2.5 years, where I was investigating and prosecuting different iterations of healthcare fraud schemes. And then after about 2.5 years, it was really more driven by my then girlfriend, now wife, was in New York. We rendezvoused in DC and had an opportunity to work for the fraud section in DC, and as a supervisor, meaning that I was able to go there and oversee, well, personally participate in investigations and prosecutions, but also oversee a number of other prosecutors around the country who are operating in different districts that, from an objective statistical standpoint, were having healthcare fraud issues. And so I worked as a supervisor off and on for, I think, about 5 years, 2 years out of DC. And then the remaining 3 years, they actually allowed me to live in the Los Angeles area while I still traveled a bunch. And this could include Central District of California, Eastern District of New York, Southern District of Texas, Middle and Eastern Districts of Louisiana. And then we had other investigations all over the place, Georgia, Utah, you name it.
You did the tour of healthcare fraud in the U.S.
I did. I like to think that I was spreading my cheer, Team America, all throughout the country. The experience you obtained was incredible. And frankly, being forced to parachute, and I know Carlos would agree with this, being forced to parachute into foreign districts where you have no established rapport with the bench or with the bar, and going in there and still bringing cases and, hopefully prevailing when you should. It was very satisfying for us. And it really taught you how to be a better lawyer.
So I would agree. I would agree with that totally. You're having to go from, again, Anchorage to, LA, and learning how to do that does make you a much better lawyer. And it's skills that we have today, because now we travel around the country representing clients. So it's the same sort of skill set.
What was Ben, what was the most challenging jurisdiction that you tried a case in? That's an unfair question, I know, but I'm asking it.
It's hard to say. I would say overall, the Central District of California was the most challenging. And listen, I'm saying this purely from the then government perspective. I would say the Central District of California.
So, Ben, who is the most memorable judge who you've appeared before?
I'd probably say Nancy Atlas in the Southern District of Texas. I tried a case in front of her. I still remember it, spring of 2010. It was like a 3-week trial. And she was just awesome. And I don't say that because she was ruling in our favor. She did a great job of protecting the record in some difficult situations. She was extremely fair. And as she was going about her business, she was also affable. So it was pleasant. It was one of those rare instances. I really looked forward to seeing her every day on the bench and having what I thought were appropriate and spirited, intellectual exchanges with her.
So, Carlos, how about you? Who's the most memorable judge that you've appeared before?
That's really hard because, a lot of the judges they're different, and some of them are terrific in their own, in their own way. Probably one of the most impressive ones that I appeared before was Judge Garrett Brown, who in New Jersey. Only because, he was just incredibly fair and incredibly efficient the way he ran his courtroom. And it was just, a real, efficient, but also, Judge Simandl, in Camden in New Jersey also just, his patience, his kindness, and the way he ran his courtroom also was terrific. There's been a bunch over the years who've been terrific.
Ben, what was your most memorable trial? I know you probably tried several dozen cases over your career. What one sticks out in your mind most as you sit here today?
Oh gosh. Yeah, I think I ended up trying, when I was with the government, somewhere between 25 and 30 cases around the country. I'm trying to think. I mean, that's a tough question. I shouldn't laugh, but I still do. I remember we had one defendant. It was actually a drug case. It was in my first year as an AUSA in Miami. Because of the time that she was looking at, I remember she passed out when the jury read the verdict, and that stuck out. But I would say, in terms of I would probably say, honestly, there was an individual who owned a series of durable medical equipment companies in the Middle District of Louisiana and around Baton Rouge. He almost single-handedly was the reason that we started up a strike force in the Middle District of Louisiana. And, we had tried to flip him before, and he was not receptive to our overtures. And we explained to him, we're like, listen, we're going to indict you not once, not twice, but on 3 separate cases. So you're going to have to run the gauntlet 3 different times. And the odds of that are almost infinitesimal. The opposite. The odds of that are so very small. And he said, no, that's fine. Take your best shot. And the first trial lasted almost a month in front of Judge Brady. We convicted him. Remember, the jury came back actually on the first day after like 6 hours. And it was one of those rare instances. I love Judge Brady for doing this. It was his practice to look at a jury and say, listen, if you want to stay beyond 5, we're happy to order a meal for you and you can stay as long as you want to. And in this instance, I think that's actually what they did. They deliberated. We got a verdict back at like 11 o'clock at night. And I was happy to see in that particular case that justice had been done.
It was, I'm sure, worth the wait.
It was. And yes, I think he was connected. I mean, comparatively speaking, it was a massive amount for the Middle District of Louisiana. I think he was connected to like, I want to say like $35-40 million in alleged fraudulent submissions for durable medical equipment, all related to, not all, but the majority of it related to like the provision of medically unnecessary power wheelchairs, if I remember correctly.
And that to me sticks out as a quintessential criminal case. I'm a civil guy. I don't live in the white collar criminal defense world so much as I live in the civil False Claims Act world. I've always wondered what goes through the minds of folks at justice when they decide to depart from the civil realm and prosecute somebody criminally. Can you maybe share the inside baseball of that, how those decisions are made? Because I'm just the humble agency lawyer.
Whoa, wow, come on now. Self-deprecation, you're stealing my MO there, Brian. Listen, I will say this. When I worked for the criminal fraud section, I think it was towards the last couple of years, we would get the steady supply weekly, but at the very least monthly, of sealed key tams. And the supervisors would be divided up by region or by circuit. And, if I happen to, like, I might get everything in the 8th and the 9th circuit. And I would review it and take a look at it. And whether or not it was civil or criminal, it was, to me, it was a fact-intensive inquiry. And what you were looking for was truly pervasive conduct that presumably has extended over an atypically long period of time, that involves an atypically high amount of loss. And if you don't have those 2 factors, you're also looking for, a patient safety or patient harm issue. You're also looking to see how many people, if it's a corporate investigation, how many people are involved. If it's at a lower level, a managerial level, or goes all the way up to the C-suite. And obviously the higher it goes up, the more likely we would be interested in possibly looking into it. So I think those are some of the different things. It's kind of like probable cause. There's no bright line test for it. It's just kind of a sniff test that you develop over years. And Carlos, I don't know if you would disagree, but that's kind of the way we looked at it.
Yeah, I think that's right. I think you look at it to see how high it goes, whether, how high it goes, whether there was any real effort to stop it. I think what I'd always heard when we're dealing with, when you were talking about prosecuting companies and making those decisions, is whether, company gets it or they don't, right? I'm sure, Ben, you've heard that, and when we tell people nowadays, you said, look, when you're trying to figure out in the real world, with a compliance budget or what you're trying to do, if you're making a real effort, to try to do things right and do it, appropriately and in these complicated times, you're not going to get prosecuted criminally. I don't think, what I tell clients, if when you're sitting across a table from somebody, if that day comes and you've got a good answer for why you did what you did and how your systems were set up, then you're going to be okay, most of the time. But if you don't, if in this day and age, you just continue to make money or you just didn't care, then you are going to get prosecuted, and it may be, criminal. And to Ben's point, nowadays, the individuals commit these acts, and I think prosecutors at DOJ are looking at the individuals responsible for it and why they did it. And I remember having a conversation one time where it was a high level, someone did an FCPA case where the decision was they were going to prosecute a high level individual because of he was aware of conduct and just continued to let it go. So it wasn't as if he instigated it, but he was constantly made aware of what was going on, certain bribes, and just let it go. And there was a very close call about that guy getting prosecuted. So, and look at some of it too. It varies, across the country. It varies with prosecutors. What may rise to the level of a criminal case in one U.S. attorney's office may not be criminal in another U.S. attorney's office. And that's why knowing the people, having these relationships is very important.
Totally agree. Great points. We would look to see if you were a recidivist, if you had been someone who had been hit up repeatedly in the past with CIDs, and not only had gone through that gauntlet, but had responded in DOJ's view in a poor or, obstinate fashion. We would look at those things. We'd also look to see once high-level individuals or the company were put on notice, either by the government or just internally, how they responded. Did they respond in the way you would want them to? And was it a quick response? And if they had an affirmative obligation to then reach out to regulators, did they honor that affirmative obligation? So those are all the things. And I 100% agree with Carlos. A lot of it depends on the district where you are, and even the individual prosecutors and agents who are investigating the matter.
Do all these same factors play into decisions about whether to pursue cases both criminally and civilly at the same time? I imagine that they do, but would be weighted in different ways in that determination.
So I would say yes. What's interesting is the back and forth that at times can occur between the criminal prosecutors and the civil prosecutors. When I was a criminal prosecutor, I know it sounds terrible, but we treated the civil prosecutors like lepers. We're like, you're going to slow things down. You're going to get in our way. Do whatever you need to do. If there's anything that you don't want us to do that you can legally tell us, that's fine. Otherwise, you stay in your foxhole and we'll stay in ours. Not everybody is like that. Sometimes the criminal and the civil folks, but I think more often than not, the civil attorneys, I don't say this in a bad way, they are a little more risk averse. They're much more guarded in their representations with opposing counsel. And yeah, I think those are the main differences. I mean, Carlos, you tell me if you disagree.
No, I think that's true. But I think what's going on nowadays is, look, for example, in New Jersey, you have the head of the healthcare fraud unit oversees both criminal and civil, right? Because I think what you see now, and certainly in the tax world, the criminal tax world, look, when you're dealing with it, you want to resolve both the civil and criminal tax issues at the same time. And back then, if somebody came up and said, I want to do a global resolution, wrap it all up, you would say that requires an act of God. We would never do that. But now, now you do, and you see them more, and it's the same thing probably in the civil context where you see the civil side of a U.S. attorney's office and a criminal side working more collaboratively and saying, yeah, look, if you want to resolve it, we'll invite the civil side to participate in meetings and, in presentations together with the criminal side. Whereas Ben's right, that didn't happen back in the day, but I think now it's certainly more common now, because I think folks want to resolve these issues together, because if you're going to pay an amount, you want to get it all resolved, and you need to know what the total exposure is going to be. So yeah, you're definitely seeing these things in people working closely now, whereas you didn't see it before, which I think is a good thing, by the way. I think it's good, because you do want to get these issues done, and it's a much better system. So
well, and what we also forget is that the recipient of this government parallel scrutiny, they oftentimes will try their best to force a marriage between the civil and the criminal folks. Because if anyone is incentivized to get a global deal, it's going to be them.
And what makes things even more complicated these days, and you see it in the context of, Fcpa, is the true global resolution, where you have global law enforcement, where you have now, because look, obviously a violation of the Fcpa, if you're a company that is based in, like a lot of companies, you do business in the UK, you do business in the United States, you do business in Italy. All of these countries have their own version of anti-bribery statutes, right? And so you could be being investigated now by all three. And that's now the case. You see that a whole lot more. So when you talk about, your risks, I tell people, you've really got to be careful. And what I think is a big risk too is China. You're there. China's got its own version of the anti-corruption statutes, and they have you can be prosecuted by the state, the more public, but you also have the Communist Party prosecutions, and those are pretty much in secret. And so you can have a very real case where you've got your operations in China. The Chinese government is conducting an investigation, and they're detaining Westerners. Right. So you're going in there, and we've had situations where we know there's investigations going on in China. We've advised, high level executives, you do not fly into China until we know for sure that investigation's over. And we've had to arrange for Chinese counsel to be present, and available for these folks in case. And we have Chinese counsel there trying to find out what's going on. And if it's a Communist Party investigation, then you've got to be extra sure what's going on, because those are not public, and it's very hard to find out what's going on. So, these are extra complications that are going on. And it's not uncommon these days, because look, for years, since 2005, right, when these really started, there's a lot of money being paid for FCPA bribes. For FCPA settlements. And other countries are saying, hey, why shouldn't we get a share of that? So now, in the past, you will see at these conferences, you will see, panels with the DOJ prosecutors. You'll see the UK guys, the SFO, and the time all sitting at the table together talking about collaborative efforts. And I'm sure Ben knows this because he was there in these units in the fraud section, that there are meetings. I think they go on every 2 months, Ben, where prosecutors meet. I think it's in Paris, where they could exchange ideas and exchange leads. And so it's not uncommon anymore that if you have to settle now maybe with DOJ, but also with the SFO and other things. So it makes this even more complicated when you're dealing with these issues. So I know we went from civil, DOJ, and the criminal side, but again, and then you could throw in obviously, the AG, AG's offices that jump into the bandwagon with a lot of these things, and you're dealing with those settlements. But look, in the modern world, when you're dealing with this stuff, these are all issues that you have to deal with, because, then you've also got potential civil suits coming down the pike that you're going to have to deal with, and potential waiver issues. So it is very complicated with all of these things.
This is a good segue, I think, in talking about FCPA a bit more. And that is a hot area of concern for corporate clients, and I think it's a particularly interesting one for pharmaceutical companies in the age that we live in, which is one of supply chains spanning multiple countries and global pandemics, where inputs for the supply chain become quite important. What do you think the biggest and I guess there's a question I'd put to both of you. What do you think the biggest challenges from an CPA perspective are for pharma companies right now?
I can jump in. Then obviously Ben has a lot on this too. But and for the pharma companies, is that when you're dealing around the world with these folks, just about in a lot of these countries, healthcare providers are officials, and then in many of these countries they wear two hats. They're customers, but they also serve on various positions in the government. Right. So you just got to be incredibly careful. Right. And also with your third parties, in a lot of these folks. So you've just got to make sure that your people know what they're doing. Every third party, every provider, all of your distributors, you've done real due diligence on them. You know what they're doing. That's what DOJ is looking at. Also, when you're sending these guys to conferences, are they real conferences? I've done many investigations in the Far East, in South America, where when you're dealing with lawsuits, are you paying success fees to lawyers? There's when you're running clinical trials, are your investigators also wearing a government hat? So if you're paying them, too much, could that be potentially a bribe? And I think with a lot of these folks too, you get the questions I get, we didn't know that these folks were government officials, and I remember interviewing folks where they legitimately said, we didn't know that paying through a third party provider, assuming that paying through an agent or somebody.
Well, and there are two separate cultures you're dealing with, right, Carlos? You've got the culture within the company that's operating abroad, and then you have the culture in the country that's abroad. And to Carlos's point, you have to reinforce top-down. Culture's got to be right, followed by, or I guess lead by example. And then, when you're dealing, what I found is most challenging, I've done a fair amount of work in the Latin Americas. Like it or not, there can be a bit of a corruption issue in certain countries down there. It's literally
not in New Jersey though. We don't have a culture of corruption.
No, not at all.
Miami, where you live, my brother.
No.
Just there.
Don't take a shot at the 305. Come on.
That would be rude.
What's most challenging is you have to recalibrate. They just don't get it at first. But when you explain to them that in order to sustain this relationship that results in them doing something and making money as a result of it, it will slowly impress upon them, okay, I have to do this the right way, or otherwise I'm not going to be making any money at all. Now, maybe the old way, I could have been making more money, but under this new improved legal way, I'll still at least have a relationship. So I think that's the hard thing, is you have two different cultures that you're trying to monitor at the same time and ensure that everyone does what they're supposed to.
You mentioned the Americas. What do you think the most challenging area of the world right now is to have those kinds of conversations?
Wow. I think all the continents have countries that have their own issues.
Yeah, I agree with Ben. And look, and it's hard. And it's also, and look, to an extent, it's almost unfair in a way because, half kidding about, I was in the public corruption unit in the U.S. Attorney's Office. And, and we have bribes here, obviously in the United States. Look, you see it everywhere. So in a way, when you look at it and you say it's a worldwide issue, right? And so it goes on. And so when you say that, Brian, it could be anywhere, and I think what's the challenging part about the FCPA is, it also, it's not just, cash, it's the benefits, and there's certain things you can do. You can absolutely, bring a government official to the United States to see how you operate and entertain appropriately. So it's not, it's not a complete ban on doing business. It's knowing where the lines are and how to do it. So, But it's knowing where those where those lines are. And look, what I tell people too, and is that as tough as some of these laws are, some of the other statutes that exist, the UK Act doesn't allow facilitating payments, and it makes it a crime if you actually don't have in place a system that prevents this. So some of these other statutes are, in a way more draconian than the Fcpa. They're just not as enforced. And right, Ben, and you look at China, and you talk in the pharma industry with the GSK one-day trial, that resulted in a $500 million fine, I believe. So that those are the challenges. And I tell people, look, at least we have a constitution, here. So if you are, subject to this, and look, there's the obvious, things that the government has a strong advantage, prosecuting corporations. I don't think that's any secret. But, I tell people, look, the last thing you want as a high-level executive is flying into a country, where that doesn't have a constitution, but has an anti-corruption statute that uses this thing for political benefit. And you get arrested in that country for violation of their anti-bribery statute. And then, it's hard. We've represented a company, that was dealing with the CPIB in Singapore, where they think nothing of calling people on their cell phones and making them come down to CPIB headquarters and give long statements before they can be released. So we've dealt with that.
Don't they cane you for leaving bubble gum on the sidewalk?
No, that's a whole other story. But
they're Brian, they're what we like to call strict constructionists of the law.
That's right.
Yes, exactly. But I'll tell you, man, one of the scariest, when you talk about representing a company, one of the scariest meetings that I had was, where one of our executives said, I'll go in and meet with them because, he's, stand-up guy who said, they're going to call somebody, I'll go in and meet with them, but I want Carlos and my local guy to go with me. And I was like, what? Dude, really? But we did, and you go in behind closed door. You're really happy to be getting back on, in Singapore Airlines coming back to Newark. I think that's a real risk, and Ben, I'd be happy to get your thoughts on that too. But, these other countries prosecuting and, being detained in other countries is I think a real risk that is, I think, certainly is of real concern, I think.
Yeah, I mean, the beauty of going into other countries that don't have a constitution, I'm saying from a company's perspective, that don't have a constitution, but do have some type of anti-corruption law is, you can operate with much, much less oversight. But if you do suddenly draw the ire of whatever party happens to be in power at the time, it can be very unfortunate for you.
You guys, and you don't want to be the guy too, if they arrest the guy, the bribe recipient in that country. I tell people, look, the first person for the get out of jail they're going to give up is the Western or the big American company or Western company that's paying bribes. So when you go in there, and they're ready to arrest you, that's a big risk. Yeah, that's a risk I would never want, to take. And that's something we use in trainings too, with folks too.
I think that the cross-border three-dimensional chess you must play in those types of engagements makes our domestic disputes probably pale in comparison. But as to those disputes, I do have a few questions I wanted to put to you guys. And I guess the first relates to what you're seeing in your practices on the healthcare fraud side. The telehealth fraud issue is a hot one right now. I saw that DOJ has come out with some statements telling the regulated community that it's going to be a focus. There were a lot of criminal prosecutions of telehealth frauds last year. Feel like Florida's always a hotbed for those things. Ben, what are you seeing down there? What are you hearing?
I mean, we in Florida welcome alleged fraud in all shapes and sizes. So bring it on down here. Listen, it makes sense. The more and more telehealth is prevalent, in the marketplace, the more federal dollars you're going to have propping it up, which means the more fraud that's going to be committed, which means the more, statistical anomalies you're going to see and that are going to get investigated and chased down by the Justice Department. That's the way I view it. I think you're going to continue to see more and more because you're just seeing a lot more telehealth that's happening, especially during COVID. So it totally makes sense. You've been seeing a lot. I think that trend is going to continue to be in place and is going to keep on going up.
That makes sense to me because you've just, like you pointed out, had an explosion in the use of telehealth. And most of what I've seen, at least publicly reported, involves telehealth frauds where there are sham doctor's visits leading to kickbacks and services prescribed that are or performed that are unnecessary, whether it's lab tests or provision of DME. Those seem to be within the realm of very clear-cut fraud along the lines of what you all discussed earlier in the program. Another issue that's been really hot lately is treatment of private equity in healthcare. And I know that both of you have dealt with private equity firms and investigations. What do you see as the big risks for them? If a PE firm wants to be proactive and reduce their risks, what are the kinds of things they should be thinking about? I mean, obviously, every company needs to have a compliance program. And so presumably every PE firm should be thinking about its portfolio companies' compliance programs and making sure that they're ahead of the ball. But are there any things that you all think should be top of mind for PE firms that want to ensure that their portfolio companies are keeping things ticked and tied?
I think on the front end before the acquisition, even though you don't want to, and even though it could potentially blow up the deal, you really need to take a long, hard look at how a business operates and if they have any historical exposure, either under the False Claims Act or possibly criminal exposure. And I think once you acquire the company, you just have to be very diligent and you have to put in thoughtful folks who, place an appropriate emphasis on compliance.
An ounce of prevention is worth a pound of cure.
Yes.
And it comes back to that, to what I said before. You really have to look at it and say, look, if something blows up right later on, do I have a good answer for what I did or didn't do?
So when the time does come that DOJ knocks on your door, despite you're not doing anything, as long as your paperwork is there and it's in order and it supports all of the claims that you've been submitting over time or somehow facilitating, then you'll be in a good position to respond.
I think that's a good precautionary note. I'd just like to thank you both for joining us today for the podcast. Really grateful for your time, and it's been a really thought-provoking and authentic discussion. So thank you.
Thanks, Brian.
Well, gentlemen, thank you so much for joining us today for the conversation. And thanks to our listeners for tuning in. For more insights on healthcare law and enforcement issues, visit MWE.com or McDermott's Health and Life Sciences News blog at healthlifesciencesnews.com. Thank you.
This material is for general information purposes only and should not be construed as legal advice or any other advice on any specific facts or circumstances. No one should act or refrain from acting based upon any information herein without seeking professional legal advice. McDermott, Will & Emery makes no warranties, representations, or claims of any kind concerning the content herein. McDermott and the contributing presenters or authors expressly disclaim all liability to any person in respect of consequences of anything done or not done in reliance upon the use of contents included herein. Copyright 2021 McDermott, Will & Emery. All rights reserved. Any use of these materials, including reproduction, modification, distribution, or republication, without the prior written consent of McDermott is strictly prohibited. This may be considered attorney advertising. Prior results do not guarantee a similar outcome.